Hello everyone, and welcome to a new Idaho 4 video. Today I'll be summarizing the most important points from a 30-something page document that was dropped on February 19th, and it deals with Frank's motion in the state of Idaho versus Brian Kohberger case. In the document, Brian Kohberger's defense team lists their arguments for a Frank's motion, which Judge Hippler denies. How, why, we're about to find out. There are also some new bits of information regarding DM's witness statement, the suspect vehicle, Murphy the dog, a few little tidbits, so let's get right into it. There's a lot to cover. One of the first topics that the defense is arguing is that it is misleading to present it as if Officer Payne drafted and did the work himself, when the PCA was in fact a collective work. As proof that the affidavit was not solely Payne's work, the defense presents emails between the FBI agent Nick Ballance and Detective Payne, and in those emails they are exchanging drafts of a probable cause statement. Judge Hippler dismisses this on the ground that the defense's argument is too technical, and that the search warrant doesn't need to be so specific, it doesn't need to state who did what exactly, especially if it still supports probable cause. He writes that yes, it's clear to everyone that Payne did not do everything himself that is stated in the affidavit, because there is a lot of information on different topics, and that would require him to be an expert on all of those topics personally. But whether he disclosed this or not does not affect probable cause. Now, I don't disagree with this necessarily, but I do have some issues with the next point, where in a footnote, Judge Hippler writes that Officer Payne and Blaker's statements are not identical. Now, I included the documents in the description, along with all other sources, as always. I'm going to put some screenshots up now so that you can compare them really quickly, but I do advise you to check the documents, the full documents, and you can judge for yourself how identical or not similar you find them to be. Now, unless I'm looking at a completely different document in regards to Blaker's statement, these two look pretty similar to me, but hey, I'm just a person on the internet. Then we get to DM's witness statement. Here, the defense tries to argue that DM was an unreliable witness because she herself stated that she has memory issues, that she doesn't remember what exactly was true and what may have been a dream, that she was tired and under the influence of alcohol. However, Judge Hippler comes to the conclusion that DM's accounts were consistent throughout her multiple interviews. The probable cause affidavits are also consistent with her accounts. Secondly, DM's interview statements that her memory was fuzzy and dreamlike and may have been affected by being tired or under the influence of alcohol do not call into question her reliability to the extent that Frank's would require. There's also a third point, but I want to stop at this second one. How is it not unreliable if you yourself as a witness come forward and say, hey, I'm not sure what was real and what was really happening and what may have been a dream, I was intoxicated? I think that's an absolutely important bit of context, but again, just my 2 cents. There is also some new information that I mentioned in the beginning. So first of all, in 2 out of 3 interviews, DM stated that when she saw the perpetrator walk past her, she saw him carrying a vacuum-like object. I don't have further context to this, but it's something new that I don't think we've heard before yet. And the second point is that DM was shown a photo of Brian Kohberger when he was arrested, and she did not recognize him there. And this ties into Judge Hippler's third point. So DM stated that she did not recognize the photo of BK, which is of no consequence considering the intruder was masked. I can kind of see that one, fair enough. Now, the defense also tries to argue that DM was unreliable on a couple of other points. For example, because she stated in the interviews that she was sure she heard Kaylee say, there's someone here, and she heard her run down the stairs. So her last direction of movement was downstairs, which defense is arguing cannot be true because Kaylee was found on the 3rd floor, therefore she could not have gone down. Judge's response to this is that the affidavit does mention that the person DM thought was Kaylee could also have been Xana, which does put DM's statement and her ability to correctly recall events into question. And this is fair, I don't disagree with this point. Judge Hippler also argues that because the PCA includes the statement about DM being in a frozen shock phase after she heard the intruder leave the house, that already indicates that she was traumatized and that her memory may be affected as a consequence of that. And that's fine, but that was after she saw the intruder, right? The PCA gives no context for what DM's mental cognitive state was before she saw the intruder, before she knew what was happening. And that would be important to know. Again, my humble opinion. Nonetheless, the judge points out that while any perceived weaknesses in DM's memory may be fodder for cross-examination, they do not negate probable cause. And to that I say fair. Fair. Now, moving on to our favorite topic, the suspect vehicle, Hyundai Elantra. The defense argues that the FBI specialist who helped identify the vehicle, he said that while he thinks it could be a 2014 to 16 Elantra, he is still leaning more towards 11 to 13 Elantra. And that was not disclosed in the PCA. The footage he was working with was pretty bad, and he wanted a better view of the fog lights and the rear reflectors. As I mentioned in one of my previous videos where I compared different models of the cars, albeit very briefly, those fog lights really are one of the only distinctions that you can kind of see, at least as a layperson. It's an element that is different from the 2014 model onwards. Now, on a low resolution footage in the dark, who knows if the shape of the fog lights was even that apparent, but either way, it is evident from this paragraph, from the emails, that the FBI agent was leaning more towards the 2011 to 13 model. I can see how similar the models of the car are, but then again, isn't it kind of a problem or kind of a big deal if you have the wrong car? I'm not saying that this is the case in this case, but I'm just saying that these little details matter quite a lot. In connection to that, we also have to talk a little bit about the timeline. Defendant points out that Detective Payne was not even aware of the ESSU officer's findings in this regard until December 20th, 2022, after defendant was already identified by IGG. However, he contends Payne Exhibit A makes it appear that defendant was identified in part through the ESSU queries. Remember when two officers found the same Elantra, Kohberger's Elantra? The PCA does kind of read this way, at least to me it did. The PCA makes it seem like they were already looking at Brian since this November date, when the Elantra was queried. But if this were true, why put out a bolo a week later saying that you're looking for a car that does not match his car? But in a footnote, it's explained that the FBI extended their search, so the range of the car, the year of the car, on November 26th, so way before Brian was identified via the IGG. But now this is even more interesting because it seems that on the one hand they're arguing, no, we had an extended search as early as November 26th. But no, you didn't. In early December, you were still looking for a 2011 to 13 Elantra. That was after the FBI agent told you that it could also be a 2014 to a 16. That means they still didn't find this extended range that relevant about a week later on December 7th. Otherwise, they would have put out a bolo for the whole range, 2011 to 16 Elantra, not just 2011 to 13 Elantra. Moving on quickly to Kaylee's dog, Murphy. So the defense makes not a very good argument, honestly, about the dog. They make 3 points. That the dog barking continued for half an hour after the suspect left the scene, that the dog was supposedly outside when he was barking, for which some tests were conducted to prove that, and they make a point that someone must have brought the dog back inside at some point. Now, the counter-argument for this is, of course, that the sliding glass door was open, Murphy could have gone back inside on his own, and then up to Kaylee's room where he was found the next morning. So, yeah, not a very good argument. In regards to the cell phone data, there are a few arguments from the defense. For example, Payne writes in the affidavit that, based on his training, criminals will often turn off their cell phones when committing crimes. Defense argues that this is mere speculation, but the counter-argument is, well, actually this is just one of the possibilities. Payne didn't claim 100% that this is what Brian Kohberger did in this case. He didn't intentionally present false facts. It's just one of the possibilities that he based off his training. There are a couple more points. I won't go over all of them, but for example, they challenge the time frame given by Payne in the PCA, but the time is about 7 minutes off, so the defense is trying to make an argument that this is false, which it technically is, but the judge argues that this isn't enough of a discrepancy to be relevant. I don't know what to think about this, because, well, what is enough then? 8 minutes, 10 minutes, 15 minutes? It does matter. Then the defense points out that Payne misled the magistrate about the location of defendant's cell phone on those 12 occasions that are mentioned in the affidavit. It's misleading because those records don't put Brian Kohberger exactly at King Road in front of that house. This one bothers me a little bit because you would think that something like this should be clarified in the PCA. This counter argument comes across kind of like, oh yeah, this is not entirely true. Yeah, we can't pinpoint him exactly in front of that house, but it doesn't really matter. Those were 12 different occasions. If they are irrelevant to this particular investigation or to this particular probable cause, why are they in there, right? Because they did, when that information came out, there were all sorts of allegations that he was stalking one or several of the victims. He was there 12 different times in front of that house, stalking them. They don't have that proof. He could have been anywhere in Moscow or that general area. The next topic is about the footprint in front of DM's door. The defense argues that the footprint is closer to her bedroom door than she reported the suspect to be. There are no other prints before or after it, and it is not positioned toward the sliding glass door, which is where DM said the suspect walked after passing by her. None of this bothers the judge. He writes that nothing is false or misleading here, and none of this makes Detective Payne's statement about the path of travel false. From one footprint, we don't even know if that's a whole footprint. It might not even be like a full footprint. Either way, how can you tell the path of travel from one footprint either way? And they're saying it's at the threshold of DM's bedroom. That is very close. But the positioning also doesn't match, so shouldn't that matter? Next, the defense argues about the lack of connection between BK and the victims, lack of victim DNA in his car and his apartment. Much of this was discovered, or rather not discovered, the lack of evidence in his car and his apartment, only after the PCA, or after the probable cause was executed. So the fact that none of this is mentioned here is just kind of self-explanatory, and this is kind of a weak argument, once again, from the defense, in my opinion. And lastly, we have the IgG. Defendant challenges law enforcement's admission in Exhibit A that defendant was identified through an allegedly unconstitutional use of IgG. I should probably make a separate video discussing that because that's a whole other 30-something page document, but I don't know if I will. So, long story short, they searched 2 databases that did not allow searching MyHeritage and GEDmatch. But the judge's response to this was that the court determined that law enforcement's use of IgG to identify defendant as a potential suspect was not unconstitutional. The court found that regardless of whether the FBI arguably contravened its own policy and contravened that of MyHeritage and GEDmatch when it uploaded the DNA profile to their databases, it was not of constitutional importance. How that makes sense? You tell me. Either way, this was the summary of Brian Kohberger's motion for Frank's hearing that was denied by Judge Hippler on February 19th, 2025. I'll read through the other 3 documents, I think there was 4 in total, in the following days, and if there is anything worth summarizing separately, I'll probably make another video on it. But for now, I leave you with this. Let me know all your thoughts on the Idaho 4 case in the comments down below. Leave a like if you enjoyed this summary, and I will be seeing you soon. Take care. Bye, guys.